An issue often comes up in forensic settings about opinions about people whom you have not examined. Well, this is addressed in two ways. First, as we noted, sometimes in such situations as a custody evaluation, or it could even be in a criminal case or in a personal injury case, there may be certain issues regarding a party whom you do not have the opportunity to examine. The ethics code speaks about our making every effort to conduct a personal examination of individuals before making any kinds of conclusions, recommendations, or diagnoses related to them. However, it also states there is a provision that if, despite reasonable efforts, you are not able to interview face to face a particular individual, you can still give an opinion, provided you qualify your opinion in light of the missing information. There are certain classes of forensic evaluations, notably evaluations to determine whether or not somebody fits the category of sexually violent predator and therefore would qualify for involuntary civil commitment, where the person may not want to cooperate with you. Under such circumstances, the psychologist, the examiner, is permitted to do an evaluation based on a record review, but must qualify the conclusions based on the missing data. In other words, say that since the person refuses to be examined, I must qualify my opinion in the following ways. It has limited validity and reliability in the following ways. Unfortunately, a number of psychologists do not follow this. They will go ahead and make statements based on somebody whom they have not personally examined with the same degree of certainty that they have in people whom they have examined. Now, there is a caution to focus on the legally relevant factors. What this means is that there is always a temptation when we do psychological evaluations to overgeneralize from our psychological test results. In other words, to say, well, this evaluation shows that this person is psychotic and therefore they must be legally insane. This person has significantly limited intellectual ability, and for that reason they could not possibly have understood their Miranda rights, or they cannot be regarded as competent to stand trial. These are inappropriate statements. The nature of the finding on a clinical evaluation is not necessarily the same as that in a forensic evaluation. The clinical findings should serve as a jumping off point to the forensic issue, to the legally relevant issue. For instance, a person's limited intellect may be only one thing that may go into their inability to understand the Miranda waiver. However, if they have been involved in the criminal justice system for many years, have been interrogated by police repeatedly, then perhaps their lack of intelligence as measured by a formal intelligence test such as the Wechsler may not be that important. So you have to focus on the relevant legal standard. Sometimes there are what are called forensic assessment instruments, which are tests designed specifically around the legal concept itself. So you need to decide what psychological assessments to use, whether or not you're going to use forensic assessment instruments, and generally it is best to use some sort of combination of these along with the different collateral sources. Always keep in mind that forensic assessment uh, uh, happens in a different context, occurs in a different context than traditional clinical assessment. Most often, you are involved in some sort of litigation, or prospective litigation, or the person is in some sort of an incarcerated setting. Use of a psychological assessment device that has been validated in a clinical setting without making reference to its specific, the specific differences in interpretation that must be made as a result of the setting is inappropriate and unethical. It is required not only by the ethics code that you make allowances for the specific context within which an evaluation occurs, but the specialty guidelines for forensic psychologists has a fairly detailed discussion of the fact that forensic settings may be and most often are different from clinical settings, and that the clinical data, the clinical conclusions cannot be transplanted directly into the forensic setting. So, for instance, if you have a test that says a test item that says that there are people following me, and the person may be involved in personal injury litigation, where in fact the other side hires investigators to follow them, that is not an indication of paranoia. Yet, if that item contributes to a paranoia scale, and the psychologist fails to include that in their assessment, they may well conclude that this individual is paranoid. In a similar manner, a defendant who is incarcerated in jail pending pending a trial may indicate there are people controlling my movements, which certainly sounds like a very psychotic kind of item. But it may refer to nothing more than the fact that the correctional officers tell them when to go into and when to come out of their cells. So psychological assessments must always take into account the specific forensic context within which they occur, and that is noted in the care forensic guidelines. Of course, we need to consider individual differences, as we did in the child custody evaluation, and again, very careful documentation and record keeping. Some would even argue that the degree of documentation, the completeness of the record keeping is even more important in forensic contexts than it is in clinical contexts. That is a debate that we really can't go into now, but certainly we do have to have very extensive documentation. Record keeping is essential. Some people have contended, and I've actually heard people testify to the fact that they do not keep records so that the opposing side cannot cross-examine them on it. That is a very foolhardy and silly approach to be used in any forensic setting, because the credibility of their assessment can really be called into question. There is an issue in every state licensing code and also in the APA ethics code dealing with length of record retention, how long you keep records. It is generally in a forensic setting different from clinical records. Most state licensing boards address clinical records. I have not seen any that address forensic records uh, differently. Um, the number of years that a record needs to be kept varies from state to state. Um, APA recently revised their record keeping guidelines approximately 5 years ago. Um, the original record keeping guidelines from the 1990s, I believe it was 1993, stated that the full record had to be kept for 3 years and then a summary for another 4 years, so a total of 7 years. The revision of the record keeping guidelines in 2007 no longer speaks about a summary. It just says keep the record for 7 years. The several states have a 5-year uh, statute dealing with keeping of records, and they then state that records can be destroyed after 5 years, except in the case of juveniles or children, where of course that 7-year period or 5-year period goes from the age of majority. So you would count 5 or 7 years from the age of majority. Of course, now that APA is 7 years, it would be wise to use the more conservative standard of 7 years. However, in forensic cases, a forensic case is rarely over. I say that somewhat humorously, but generally it is true. Custody, in a family law case, custody is always subject to reevaluation. So you never know when your testimony will be sought. It may be 3, 4, 5, maybe 10 years down the road. In a similar way, a criminal case or a civil case may go through a process of appeal, and the appellate court may rule on something, may send it back to the trial court, and you will find many years later a request for your records. So generally, forensic records should be kept as long as possible. My personal practice is to use that 7-year cutoff point. I will at that point discard all of the secondary material, all of the police reports, witness statements, employer records, and so on. But I keep my own records, my own psychological test data, my own notes based on review of the other records, my own interview notes. I keep those indefinitely. So I think that is wise within a forensic case. Okay, the final thing I want to address is the issue of professional communications. As we mentioned before, you have an ethical obligation to present all data upon which your conclusion has been based, but sometimes there are problems there interfacing with legal advocacy. In other words, an attorney may not want certain kinds of information to come out, but you, on the other hand, have an ethical obligation to reveal all material on which your opinion is based. Now, this becomes very important for you to meet with an attorney before the time of your testimony, to go over the data, to talk about how you reached your conclusions, what data you have, how the various ways in which that data can be interpreted. You always need to explain the relationship between the data and your legal conclusions. You have to show how a particular finding, say that an individual is delusional or is hallucinating, may impact on a particular legal standard, such as their not being able to appreciate the wrongfulness of their behavior, What is it about a particular delusion or hallucination, or limit in their intellectual ability that makes them unable to appreciate the wrongfulness? You need, again, to provide, as I said, all relevant data, but to avoid information not relevant to your opinion. So, in fact, you may come up with a number of pieces of data that really do not feed into your final conclusion. And those you do not have to, you don't have to include that sort of information, because you are required to provide all material upon which your opinion is based. The final thing that I want to talk about is, again, impartiality, but in another context. Impartiality regarding statements about other experts. Very often, especially in a high-profile case, you will be encountering opposing experts testifying. You may have had an opportunity to review their data. They may have had an opportunity to review your data. Perhaps you feel that they have interpreted your data incorrectly, that they have reached conclusions that they shouldn't have reached, or that they have ignored material in their own data that they should not have ignored. You do not want to go on the witness stand and say something about their reputation is tarnished. These are actual words, by the way, of someone I once know who got in trouble for saying that about an opposing expert, that their reputation is tarnished, that they are highly unethical for interpreting data in that particular manner, that they are unprofessional for doing so, that they are negligent for doing so. You want to avoid any of those conclusory kinds of statements. No matter what you personally feel about the person's lack of ethics or lack of professionalism, you really want to avoid making statements like that. Stick to very objective, factual statements, such as Dr. X's conclusions, Dr. X's testimony do not seem to be supported by his or her data. And then you can state why you think the conclusions cannot be stated. Leave out any reference to Dr. X being unprofessional or negligent or unethical. Finally, avoid making out-of-court statements and commenting about certain legal proceedings. Even though if you are an expert in a particular case, and are asked for a statement about that case after you've come off the witness stand, it is wisest to avoid making those statements. Even though ultimately a court will probably rule in your favor and will say that you are merely repeating what you said on the witness stand. I know of many cases of psychologists who have been hounded by malpractice cases, by defamation of character cases, for making out-of-court statements. Restrict yourself to a simple no comment. Make your statements only while you are under oath. Okay, that pretty much takes care of what it was I wanted to talk about today. So I hope that this has been of some assistance to you, helps you understand the rocky contours of much of the material in ethics and the law, and I look forward to seeing you on another occasion. Thank you very much.